Well, we know so many of you value the opportunity to ask questions of our experts. Today, Leanne is in the studio with lawyer Dave Hollingsworth. He's here with some changes to insurance we should all be aware of.
Michael, we have great questions, and yes, relating to the changes in insurance legislation, the law has changed, your coverage has changed, but you may not have even known it. Lawyer David Hollingsworth from OttawaInjury.ca is here with us to talk about that and to answer and offer some free legal advice. So as of February 1st, a change that will affect anyone who has been injured.
That's right, Leanne. We've talked in the show before about accident benefits, and anytime you're involved in a car accident in Ontario, you're entitled to certain accident benefits if you've been injured. One of those benefits is attendant care. So attendant care is basically if you've been seriously injured and you're discharged home from the hospital and you need help getting around or cleaning yourself, toileting, meal prep, a lot of these basic activities of daily life. If you need help with those, you're entitled to attendant care benefits. And it used to be before September 2010 that if you needed 24/7 care and it was a result of these injuries, you'd be entitled up to $6,000 a month. That was up to September 2010. The insurance companies didn't really like that. They lobbied the government, and then they said, well, we're not just going to give them $6,000. The injured person has to prove that they have incurred some expense of some type in order to be entitled to the money. So that was fine. That was, even though the premiums were the same, the benefits were somewhat restricted. And then last year what happened was there was a woman whose son was very seriously injured. The doctor said that he needed $9,500 worth of care. The maximum was $6,000. She had to leave her job to now become 24/7 nurse for her son. She was doing this. She submitted her bills to the insurance company, and they said, no, we're not going to pay the $6,000 even though everyone says he needs it. We're only going to pay you what you're missing out on from work.
So essentially, the model has changed. So, and there's some discrimination based on the model. Explain that.
Well, yeah. So what happened was the court sided with the mom, and then saying that no, she gets the full $6,000. And then the insurance companies went to the government. They got it changed, and now the government says the care provider is only allowed to be compensated to the extent that they have incurred expenses. In other words, this mom who was working, making $2,000 a month, who's now been thrust into a job of being a full-time 24/7 nurse, is only going to be paid the same amount that she's being paid at her other job.
And where this, so if someone, you were giving examples.
Yeah, right.
So if someone is a parent of someone who's injured, or a spouse.
Right. Yeah, sure. Well, let's say for example, you've got a stay-at-home mom who's got maybe raised 5 kids and has excellent nurturing experience. Let's say she is now going to be taking care of somebody on a 24/7 basis. She's going to be entitled to zero money for attendant care. However, let's say her spouse, who is a plumber or an accountant, they stay home from work to care for this injured individual. They'll get up to $6,000. So you could have the exact same policy, the exact same premiums are paid, the exact same care is being provided, but you could have one person who gets zero money for it and another person who can get up to $6,000.
The reason you wanted to talk about this today is because it does essentially, potentially affect everyone.
Absolutely.
But it's not the kind of thing that everyone knows about. It's a legislative change, not a change to the actual insurance policy.
That's right. Yeah, so the policy remains the same. Your premiums will probably stay the same. It's just your access to benefits are now very significantly restricted and reduced.
Okay, well, thanks for the heads up on that. We are going to get to some really, really great questions, and I don't know what it is, but February also always brings about so many questions about wills. I guess people are inside and doing their paperwork, and we have a question from Gord, and it says, are you able to do your own will? And should it be handwritten, and should it be signed? That's the first part of Gord's question.
Okay, so if you do your own will, I mean, you can go to online and there are will kits and things like that, but assuming that you are sitting at home on your own without a will kit, a holograph will is a will that is written out by hand and signed. Now, there are very strict rules. If it's a holograph will, it has to be all handwritten and then signed at the end, and then it can be valid. However, if any part of it's typed, then it's no longer a holograph will in the same sense, and there are much stricter rules required. Namely, it has to be witnessed by more than one person, and the people who are witnessing it cannot be an executor or an estate trustee under the will, and they cannot be a beneficiary under the will.
So you've essentially answered the second part of Gord's question. Just quickly, I have previous wills and was thinking of scanning them and making minor changes and then printing them, signing it, and dating the document. Would that be legal? So I
would think that would probably be be unenforceable or could be unenforceable. I think that if you're going to type a will out, the requirement is then to have it properly witnessed with 2 witnesses who witness the signature at the same time, at the same place, and they can't be a beneficiary under the will.
I've heard lawyers say that if you can't get in to actually do a formal will, do your own holograph will, because at least it is something. We're going to be
Absolutely,
back with more of David Hollingsworth, Michael.
Well, now back to Leanne with something we all like, free legal advice.
And Michael, we're going through a number of questions in really short order. We have you on the seat, Dave.
Okay.
I was injured getting off an OC Transpo bus last month, didn't report it. Now my sciatica has flared up so much that I haven't been able to work for the past 2 weeks. I've read you must report accidents within certain timelines. Is it too late?
Well, there are timeline requirements. You're supposed to get notice in within 10 days, but I've gotten around it before, so don't let that be the thing that stops you from making your claim. Let the city know right away.
So, but typically it's 10 days.
10 days for certain things, including this, and but I would get the notice in now.
Now, is that different because it's the city? Because when we know of a statute of limitations, there's a longer period of time, isn't it?
Yeah, it's 2 years. Typically, the statute of limitations is 2 years, but they want to give the city an opportunity to go out and inspect before things get changed, you know, before ice melts or whatever. They want to give them a chance.
It's February, told you, back to wills. Do I need a will if my estate is small?
I would say yes, because a will, it's not just about what's in the estate, but a will also usually appoints an estate trustee or more, which is the person who, otherwise known as an executor. They pay off your bills, they let the bank know and all these things, so you can, you know, there are other things in the will aside from just divvying up what you may have.
Right. Is a will confidential, and can it be corrected?
Sure, it's a legal document, it's your own, it's confidential, you can keep it with your lawyer, people often do that, or keep it in a safety deposit box. So yes, and can it be corrected, did you say?
Yes.
Yeah, so a correction to a will is called a codicil, and it's an additional document that's added on to the will. I think that was probably more common when people typed out wills on typewriters. Now people just do new wills up on a computer and revoke the old will. But yes, it can be corrected.
Okay, next up, we are going through these quickly. I was in a car accident 1.5 years ago.
Right.
I've been getting benefits, and now my insurance wants to settle my file.
Right.
They've been very cooperative and said I don't need a lawyer. Is this true?
Well, I think for certain large claims, you do need a lawyer. I don't think they're allowed to settle without you getting legal assistance. But for other claims that are not so large, you don't have to have a lawyer. But odds are a lawyer will probably be able to tell you what benefits you may require in the future, and they can usually help negotiate. So you don't have to have a lawyer, but it's advisable.
Advisable, okay. And someone's heading to small claims court. They are wondering, do they need a lawyer?
Well, the small claims court jurisdiction in Ontario now is up to $25,000. So, you know, the stakes are a lot higher than they used to be. I've probably done 30 small claims court trials, and, you know, if it's a $1,500 invoice, maybe not. If it's a complicated question with complicated legal issues and lots of witnesses, then it's probably worth your while to get some legal assistance.
So we're going to try to get 2 more questions in.
All right.
Should I make my children executors in my will?
Well, often they're the people who are best suited to do it. However, wills can often bring out, the states can often bring out the worst in people, and it may pit them against each other, and you're dividing up assets. Sometimes the recommendation is to maybe get an outside person, like a sibling or somebody who's slightly further removed, who's not a beneficiary under the will.
And speaking of bringing out the best or the worst, our next question is, do I need a lawyer for an amicable separation?
You can do whatever you want. I would strongly suggest that you get one, because especially when things are amicable, that's when you want to get them reduced to writing, because people's memories fade, and interpretations often become different. Somebody new comes in the picture, and then suddenly it can get quite complicated. I think you want to hammer down the details, make sure you don't miss out any important details, and get it done right to avoid any future problems.
If it's amicable, could both parties share the same lawyer?
Well, yes, except typically I think what would have to happen is the lawyer would then send one of the parties out for what's called independent legal advice. And so one lawyer can draft it up, but they'll probably require one of the parties to go out and at least get an opinion to make sure it's fair.
We want to thank you. That was sort of Olympic. You did that in Olympic time, David.
We want
to let you know that there's a link to David's website on our website. Michael, did you have a question?
No, I just want to congratulate David on his Olympic gold medal.